Facebook. Hey, many people are aware of it. Lots of people use it. But what happens when a school attempts to restrict what a student can or cannot say on Facebook when they're using it in non-school time? Well, that takes us to this week's case. It involves a mortuary student at the University of Minnesota. And she was involved in, of course, the study of mortuary sciences, and that included dissecting cadavers. On her Facebook, she posted some what were considered to be derogatory, she considered them as humorous comments regarding the cadaver. The school complained. School obviously became aware of this, and the school then took some pretty vigorous action. It gave her an F in the course as punishment for posting these kind of comments and subjected her to other disciplinary action. She said, no, you can't do that. You can't do that. It's my Facebook, and I am doing this off campus. I'm doing it on my own time. I'm not doing this in the classroom. And you cannot control my conduct off campus, and especially you cannot control my free speech, because to do so is violative of the First Amendment. Why? Because you, University of Minnesota, are part of the state of Minnesota. You have an obligation to adhere to the Constitution of the state of Minnesota and the Constitution of the United States. You are treading on my rights of free speech when you, in some way, criticize or punish me for what I post on Facebook. All right. The school, University of Minnesota, said, no, 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 no. This is a legitimate state interest. We have an interest in maintaining in the classroom and in the conduct of this profession of mortuary science, professional, ethical approaches which are appropriate to the science. That means that we can't have people making comments that are going to be derogatory about cadavers which are donated, because people who later may donate them may not have an interest in doing that, since they are going to be ridiculed. Okay. Well, young lady filed suit. She said the punishment she received was inappropriate, was not warranted, was violative of her First Amendment. University of Minnesota made the arguments it made, and it found its way into the court system and moved forward and went all the way up to the Minnesota Supreme Court. Minnesota Supreme Court heard both arguments, gave it consideration, and came away saying, you know what? University of Minnesota, you're right. Because, yes, there is freedom of speech, no question about it. But you have articulated a clear and compelling state interest as to why, in a very narrow way, free speech should be curtailed. You have said that it's a result of the need to have a professional, ethical code of conduct that applies in this instance. And in our ruling, we are narrowly writing this ruling so that it only applies to Facebook postings which violate the code of professional conduct that you have established at the school for a profession such as mortuary science. So, University of Minnesota, you're right. Yes, she gets an F, and we move on from there. So what do we learn from this case? Well, we learn an important thing, that something we all know we have in the United States, a First Amendment freedom of speech protection. We also learn that the state, in this instance an arm of the state, University of Minnesota, can curtail speech if it has a legitimate state interest. Here, that legitimate state interest was to see that a code of professional conduct regarding a profession was properly adhered to. And also, speech can be curtailed if it's done so very carefully. And here, the court made that very clear and said this only applies to Facebook postings that violate a professional code of conduct that has been established, as we can see here, for mortuary sciences or any other professional code of conduct, we would think. All right. Hey, we bring you this case as we bring you cases every week so you understand how the law works. I'm David Allen.